Moving on to the rapid fire panel today. Participating is first introducing myself, Alexis Alvarez, Director of Statewide Training at Florida Legal Services. It's been a pleasure to be with you all. We also have Jocelyn Armand, who is the Advocacy Director of the Health and Maintenance at Legal Services of Greater Miami. We have Katy DeBriere, Legal Director at the Florida Health Justice Project. We also have Lizzie Johnson, Staff Attorney at Community Legal Services of Mid-Florida. Not last but not least, we also have Katy, who's going to be last. But we have Tequisha Myles, Supervising Attorney at Legal Aid Society of Palm Beach County, and Katy Grunewald, Disaster Coordinator at Legal Services of North Florida, and truly the person that put all of this together and brought this all to you. So it's been a pleasure working with Katy on this, and thank you, Katy. So I'm going to turn this over first up to Jocelyn. What is your hot topic?
Thanks, Alexis. Good afternoon, everyone. Like Alexis mentioned, my name is Jocelyn Armand, and I'm an Advocacy Director at Legal Services of Greater Miami, down in sunny, humid Miami, Florida. This afternoon, I wanted to chat with all of you rapidly about Social Security overpayments. I don't know if, like us, you've seen an increase in these cases, but we've recently seen a lot of clients coming into our office with these issues. So I thought we'd talk about what we do over the next couple of minutes and how we approach these cases. We see these mostly in the context of SSI recipients, but we do see them with other benefit recipients as well. So I'm going to really speak generally to overpayments. So as most of us know, a Social Security overpayment occurs when the Social Security Administration finds or determines that a Social Security recipient received more benefits than they were supposed to receive or were eligible to receive. And like I mentioned, for us, we see these more in the SSI context, but they do affect everybody. So when a client first comes into our office with an overpayment, the first thing we try to determine is whether or not we can appeal the overpayment. And so Social Security overpayments, like a termination or like a denial, is appealable to the Social Security Administration. You have to follow the same time limits, so 60 days from when it was assessed. And the Social Security Administration should, and I say should because we find sometimes that they don't always do, or magically things get lost in the mail, but issue a notice where they're explaining to the recipient what's the reason for the overpayment and what is the time period for when the overpayment occurred. And so the first thing we do is figure out with the client, is this overpayment correct? Were you really overpaid these benefits? We've seen recently, again, down here, that we've had a handful of SSI recipients come in with reported income. And it turns out that somebody's actually used their Social Security number and reported earnings or wages under that Social Security number. And so that then becomes an issue with, the IRS and fraud and things of that nature. But that is a typical example of an overpayment that is not correct, right? This claimant did not work, did not earn this money, and as a result should not be having or not be assess this overpayment. And so just like a denial or a termination, you would file a request for reconsideration with the Social Security Administration. Like I mentioned, 60 days is the timeline, but you can always allege good cause in the event of a late appeal, which happens a lot with our elderly and disabled clients, right? They don't know what to do. Maybe they didn't get the notice timely. They're not checking their mail, whatever it could be. I do want to point out that while an appeal is pending, the Social Security Administration should stop recovering the overpayment from the beneficiary's monthly payments. And so that's really important because, again, sometimes that doesn't always happen. And so we want to make sure that if you have a client who's appealing an overpayment, that you make sure that the administration stops the recovery. And then, of course, in the event that request for reconsideration gets denied, you have the option of going to a hearing. And then if, you're not successful there, there's the appeals council and federal court route. Now, in the case, and this happens sometimes where this overpayment is correct, because sometimes that happens, there is the option to request a waiver of an overpayment. And so that's a different form. But what's important to know about a waiver is that you can ask for a waiver at any time. And you could ask for a waiver multiple times. So not unlike the appeal where you have to do it within 60 days or having good cause for filing a late appeal, with a waiver, you could request that at any time. And so, we assess our client's ability to pay back this overpayment if the overpayment was indeed correct. And if they can't and they really didn't intentionally cause the overpayment, then we ask for a waiver. And sometimes, we ask for multiple waivers depending on the client's situation. So that is done by completing and filing a request for waiver form. It's a very creative name, but that's what it is. And so you file that with the Social Security Administration for them to process that waiver. Before I kind of go into the basic details of what you would need to show, I do want to mention that for smaller overpayments, typically $1,000 or less, Social Security will usually automatically waive those overpayments. So if you do have a client that comes in with a smaller overpayment, I definitely encourage you to help them submit either an appeal or a waiver, because usually when they're smaller overpayments, the Social Security Administration will waive them. So when it comes to actually requesting a waiver, you need to really show two things. One, that the overpayment was not your fault, wasn't intentional, and two, that you can't afford to pay it back. A very common example for us is when our clients do report changes to Social Security, and Social Security just doesn't do what they're supposed to do, right? They don't adjust the benefits. They don't, do what they need to do. They don't recalculate. And so it's not their fault. They called, they did what they had to do, and then Social Security just didn't, do what they did. So that's a very typical and common example of, this overpayment is not my fault. And then I'm sure we could all agree that for most of our clients, it's easy to show that they can't afford to pay it back, because our clients are very low income, and it's easy to show that, particularly for SSI recipient clients. It's, right now the max, is a little under $900, and who can live with that? So as long as you could show that it wasn't intentional and that you can't afford to pay it back, Social Security should waive the overpayment. If it gets denied, there are appeal rights as well with a waiver, with a denial of a waiver. I kind of want to make sure that I make a push for helping clients with overpayments, because the Social Security Administration could definitely recover from monthly benefits, and that can be a big deal for clients. For SSI recipients, they can take up to 10% of their check, and so that's a little bit under $100 a month, and that's a big deal for a client on such a fixed and small income. And then for non-SSI recipients, they could actually recover the entire amount of the check. So it's very important that, we kind of help our clients with these issues, because it could very easily mean, their ability to pay rent or afford medication or whatever it is going away. Some things that we do to make sure that, that we advise our clients to try to avoid these things from happening is making sure that we explain to our clients it's important to report changes to Social Security, and make sure that when they do that, they keep copies or proof or details as to how and when they did that, because in the event of an overpayment, that is going to, substantiate their request for a waiver or come to that. That they report changes, not only income changes, but also marital status or living situation, and that's more for SSI recipients, but it is important that that we educate our clients to do that. And another big one that we see a lot is related to resources, making sure particularly our SSI recipient clients know what would make them ineligible on the resource front, what the eligibility criteria is, and how they can spend down resources if they do come into resources, and what are the right ways to do that. So that was my overview of overpayments in a very rapid fashion. But if anybody has any additional questions or wants, I would, you can contact me or email me, and we could definitely talk a little bit more about the subject. So Alexis?
Awesome. Thank you so much, Jocelyn. One question did come in, actually. The question was, what is considered a small amount of overpayment for waiver purposes?
It's typically $1,000.
$1,000 or less, I assume, right?
Yeah.
Awesome. Well, thank you so much. On to our next presenter, Katy DeBriere. What's your hot topic?
I feel like I'm on a talk show.
I
Hey,
know.
everybody. I actually have not one hot topic, but two hot topics that I'm going to talk about. And they're both related to some work that Florida Health Justice Project is doing around elder justice issues. So the first hot topic is we provided, in partnership with Legal Services of Greater Miami and Disability Rights Florida, as well as Jacksonville Area Legal Aid and Florida Policy Institute, some rule comment to the HCBS settings rule that is a federal regulation that governs the various protections and how home and community-based services setting needs to be arranged in order to ensure maximum integration of people with disabilities into the community. And of course, that includes, when we talk about people with disabilities, we talk about individuals who are elderly that need some assistance, live in home and community-based services settings, such as Medicaid-funded assisted living facilities. So in that regard, what we were doing is looking at very specifically the eviction protections rule that falls under the federal regulation of the HCBS settings rule. And that rule specifically reads that the unit or dwelling is a specific physical place that can be owned, rented, or occupied under a legally enforceable agreement. So the agreement between the resident of the ALF and the ALF provider by the individual receiving services. And the individual has at a minimum, so this is a requirement the HCBS, the federal regulation, places on HCBS settings providers such as ALFs, the same responsibilities and protections from eviction that tenants have under the landlord-tenant law of the state. For settings in which landlord-tenant laws do not apply, which is arguably Florida, because we have very minimal protections when it comes to evictions from ALFs, the state must ensure that a lease, residency agreement, or other form of written agreement will be in place for each HCBS participant, each ALF, Medicaid-funded ALF resident, and that document provides protections that address eviction processes and appeals comparable to those provided under the jurisdiction's landlord-tenant law. So it's our experience and practice that the eviction protections provided to ALF residents are very minimal. And that, of course, is based on Florida statute, specifically Florida statute 429.28 subpart K, which I will summarize rather than read so nobody is falling asleep on a Wednesday afternoon. And it essentially means that the ALF just needs to provide 45 days written notice to the individual before they move to discharge them. So that is at odds, is not comparable to our landlord protection statute. So what we did is we drafted some rule comment and sent it to the Agency for Healthcare Administration, which is the state agency responsible for ensuring that the protections under the HCBS setting rule are met. And we expressed our concerns in terms of the variation in the state statute in terms of eviction protections for ALF residents versus that in federal regulation. We invited the agency to work with us to ensure that the lease agreements that are being executed now and in the future comply with the HCBS settings rule, rather than just providing for the minimal protections in Florida statute. But I think the main takeaway here on the rapid fire panel is to understand the HCBS settings eviction protection rule and understand that if you are involved with individuals, with clients who are being evicted from an ALF setting, the ALF is required under federal law, if they receive Medicaid dollars, to again provide protections comparable to the landlord-tenant law, which is going to be more than 45 days written notice without giving the individual the opportunity to challenge that in state court. So moving on to the next hot topic, we are also at FHJP working on litigation around the state Medicaid programs exclusion of coverage for adult incontinence supplies. So there are several cases around the country, including a case known as Hildebrand v. Levy, which very clearly states that Medicaid coverage of incontinence supplies, incontinence briefs are a mandatory coverage provision under the Federal Medicaid Act, and therefore the state has no discretion in terms of whether or not they want to provide coverage. Additionally, there have been significant successful cases in other circuits stating that the failure to provide that mandatory coverage implicates the individual's rights under Title II of the American with Disabilities Act, and specifically their protections related to being able to receive services in the community as opposed to in nursing facilities. And what that really means on the ground is here in Florida, that exclusion of incontinence supplies for adults applies to individuals who live in the community who are not on a waiver, those individuals who are on a wait list for waiver services but are in the community. But if an individual chooses to go into a skilled nursing facility, those supplies are covered. So that, again, implicates the rights of individuals in terms of Title II of the ADA and the state discriminating on the basis of the person living in the community as opposed to choosing an institutional setting. So we love to speak with affected individuals who are unable to access adult incontinence supplies under state Medicaid plan. And you're welcome to contact me. I believe my contact information should be in the materials that were provided at the beginning of the conference. So those are my hot topics. And just as Jocelyn offered, we are also always available to talk more. Thank you so much.
Awesome. Thank you so much, Katy. And so next up, we have Lizzie Johnson. Lizzie, tell us your hot topic.
Hi, again, my name is Lizzie Johnson. I'm the managing attorney for the older adult programs here at Community Legal Services. I'm going to talk to you briefly about caregiver resources available for Florida's aging seniors and veterans. And like my other panelists, my materials are available on the platform. In 2015, the Pew Research Center estimated that 19.1% of Florida's population is age 65 or older. Today, an estimated 25% of Florida's population is over the age of 60. The Florida Department of Veteran Affairs reports that Florida has the third largest veteran population in the United States. 7.5% of the nation's 20 million veterans reside here in Florida. Homelessness. The department also reported that homelessness among veterans in Florida has decreased by almost 70% since 2010, partly because of national initiatives to end veteran homelessness, such as the VA Supportive Services for Veteran Families and the HUD VA Supportive Housing, or what we call VASH vouchers. It is well reported that most seniors and the disabled desire to age in place. Adequate legal planning is essential for this to occur. Sadly, many individuals and families fail to make an effective legal plan. Some seek legal help until it's too late, such as when a person has lost capacity. Others, they draft a plan that's wind up being ineffective. Or they designate a caregiver, a POA agent, or a health surrogate who unfortunately passes away, falls ill, suffers from an addiction, refuses to serve, or lacks capacity themselves. These families find themselves in murky waters. Now they must navigate caring for their loved one without the legal authority to manage their property, handle their finances, determine whether this person is going to live, prevent abuse or exploitation, or even to apply for financial assistance with governmental programs. The VA declares that America is becoming a nation of caregivers. According to a 2015 AARP report, an estimated 34.2 million adults provided unpaid care to an adult age 50 or older within the prior year. These family caregivers spent at least 24 to 40 hours per week providing care to their loved ones. The RAND Corporation found that post 9/11 military caregivers, they differ from other traditional caregivers. Of the estimated 5.5 million military caregivers, 20% are caring for veterans and service members who served post 9/11. It's reported that those wounded warriors tend to have disabilities, which requires additional care that these family members are also providing. Last year, the Journal of American Geriatric Society reported that family caregivers of veterans experience high levels of burden, distress, and financial strain. The VA, the AARP, and many other think tanks, they have found that traditional family caregivers have this same burden and distress. Caregivers supervise their loved ones to prevent them from wandering or harming themselves. They assist with bathing, cooking, dressing. They help develop and implement and manage treatment plans. And they often provide the typical task that's performed by an actual nurse. And again, these caregivers are doing this all unpaid and often without help. 22% of caregivers report that their physical and mental health has gotten worse as a result of caregiving. Some suffer from depression and isolation. Many feel there's a lack of privacy in their own homes. They often have difficulty setting boundaries. A lot of them suffer from financial distress because they may have given up a job to take on the caregiving role, or because they're simply unpaid. Many suffer from sleep deprivation and often feel ashamed, afraid to seek help, or do not know where to get help. The VA has done multiple studies, and their researchers within the VA often have said that more clinicians need to do more comprehensive research, and the nation, along with the states, they need to provide better assistance to these caregivers, because if they do not, it's going to negatively impact not just the caregiver, but also that wounded person whom they're assisting. The VA offers a lot of programs to caregivers. One of the main ones is the program of comprehensive assistance for family and caregivers. Again, I have provided the most recent expanded eligibility guidelines in the materials. But the benefits include a monthly stipend, mental health counseling, respite care for up to 30 days for that caregiver, possibly health insurance if they qualify, and other benefits that directly help the caregiver so they can continue to assist that disabled veteran. The state of Florida Department of Elder Affairs has an elder resource helpline that will screen you for many different services that the state of Florida offers, such as the long-term ombudsman's program, if you have a problem with the ALF or a nursing home, as Katy just discussed, that they oversee and fund the elder abuse hotline. They have a community and the home and community-based programs. They oversee that. They manage and oversee the Florida Senior Legal Helpline. They have SHINE, which assists seniors or older populations enroll into healthcare programs. But they have so many more programs that I can't even discuss. And you really should call the Elder Resource Helpline to see what you qualify for. Also, just on a side note about legal planning, almost every county in Florida has access to a legal aid. Legal aids typically receive state and federal funding where we can provide no cost or low cost legal assistance to Florida residents. We are available, we're ready, we're here to help seniors and veterans throughout the state of Florida. Just pick up the telephone. If you're a caregiver, just give us a call. Many caregivers, they have problems with power of attorneys, possibly guardianship, preventing and protecting seniors and veterans from elder abuse. They may even be accused of abuse or neglect, maybe from a spiteful family member. They may need help with a probate once that loved one passes away. But in closing, I just want to remind you all that it's okay not to be okay. And just know that you are not alone. The state of Florida has a lot of resources. The nation has a lot of resources. Just give anyone a call and we can direct you to their appropriate place to get help. Thank you.
Awesome. Thank you so much for that, Lizzie. That was really motivating. All right, next up we have Tequisha Myles. Tequisha, what's your hot topic?
Good afternoon. I'm going to talk housing. Yay! Housing, housing, housing. So I'm going to give you 5 issues that impact a senior and their housing stability. So the first issue is the raising of the rents. So in South Florida, that's a major issue. And I read news articles and news stories all across the state of Florida that it's not just a South Florida thing, that rents are being increased all over. And although it's being increased from every demographic, it's most impactful and hurtful on our seniors who are on fixed incomes and may be due to age or disability unable to work. So with the small pot of money they have and rents going up, they have to try to figure out and make some really tough decisions about how they will continue their housing plans. I don't have a solution for that. I know that many cities and counties are enacting ordinances that are putting caps and putting some time delays on the rent increases. So hopefully your jurisdiction will have one soon. They're doing it in Miami-Dade County. Broward has done it. The city of Lake Worth. I believe Hillsborough or Orange County has done it or is considering it. So hopefully that movement will go across the state and more protections will be in place. And ideally our Florida legislature will do something about it, but I'm not getting political. Issue number 2. Homeownership scams. And so that is a major issue for our homeowners. And so I am not a homeowner, but I got the following text, and I'm going to show it from my phone. Reaching out, bearing great news with a lovely unheard of deal on your residence. Once again, I don't own a house. I set out to get in touch with you a few times and appear that we've missed. If you're thinking about selling, please give us a call. And here's a peek at a quote. Now I know if I click on this link in my text, I'm going to open up a can of worms. So I know better. I know how to block the call and say bye-bye. But our seniors, they have this duty to answer all phone calls, this duty to answer all emails, the duty to answer all texts. And so they're going to click on that, or there's someone that's going to come to their door. They're going to be very friendly and nice, and they may get themselves scammed or duped or unduly influenced. And so we want to protect our seniors, arm them with information that there are people out there that will scam them. And when you think of Florida, you think of a lot of things, Mickey Mouse, Donald Duck, and you think of scams. And so most scams start here, in here. And so we want to protect our seniors from these types of scams. Issue number 3, taxes, property taxes going up, going up, going up. Some of our seniors have paid off their mortgage, so they think they don't have to worry about property taxes. Some of our seniors have it in their escrow, and the escrow account gets kind of wacky, and so then the taxes don't get paid. Some of our seniors get a reverse mortgage and think, I've got a reverse mortgage and I don't have to pay my property taxes. Wrong, 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 wrong. And what happens is we have a lot of seniors that find out at the last minute that their property has been delinquent, the taxes have been delinquent for a number of years, and now the property is going to be up for sale in a tax foreclosure sale. So we want seniors to, every year, look at their homestead exemptions, make sure they're qualifying for everything that they can get. Disability allowances, widow allowances, they are a veteran, whatever they can qualify for, they need to make sure that they are getting it and it's being put on their property taxes, on their property tax records. Issue number 4, we have the people who are, once again, our scammers misusing our deeds. And so they get people to sign off on a deed, sign off on a piece of paper, and they think that it's some good paper, and it's find out that they have sold or transferred ownership of their home to someone else. We had a case recently here where one of our clients was having a stroke. Good Samaritan neighbor, we thought, takes client to the hospital, goes to visit the client a couple days later and gives him some papers, and our client in his 80s just thought there was some papers to sign to help with visitation. Turns out he signed over his property to his neighbor. And when he goes to the rehab center after his stay in the hospital and is released home, he's now released to a second bedroom in his house, and his neighbor friend, Good Samaritan, has moved into the master bedroom. And so we've got to stop these scams that are criminal and just really wrong. So we got to make sure that people know what to do and protect themselves. Just about every clerk or court offers a property fraud alert. You go on the clerk's website for your county and click on property fraud alert. All you need is to enter your name and your email address. When a document like a deed or a mortgage is filed in your name, you get an email notification that there has been a filing under your name. If you know that you have not filed, you've not got to refinance, you've not done anything to impact your ownership of your home, then you know you need to get down to the clerk's office to find out what's going on. Okay. Finally, issue number 5, heir property. Grandma wanted me to have this property. Grandma didn't write it down. Grandma didn't put it in a will. Grandma didn't do a deed. So therefore, grandma's now giving this property to all of my cousins, all of the siblings, all of these heirs. So we want to make sure that we deal with heir property. And so the issues that come up when we don't properly deal with heir property is that it's the most unstable form of home ownership. You're not going to get homestead exemption, property taxes. That'll be a problem down the road. The owner's not clear title. Somebody wants to sell, then we're going to jeopardize everybody's ownership interests. And then if their person needs mortgage assistance, or they need to repair the home, there's no owner that can go and produce clear title to a county to get their financial assistance that they might need to make very important home repairs. Or hurricane somebody comes through, and who gets the right to do the home insurance claim and get those proceeds. So we have to be proactive. We have to make sure that we have good estate planning documents done, and we have to make sure that we have good deeds. We don't go to Staples and LegalZoom.com and buy our deeds. We get deeds done by a lawyer. And I bet most legal aid offices will help you get a deed done, or at least give you the right direction on where to get a deed done. Okay, so those are my 5 issues that impact a senior from having stable housing. Thank you.
Awesome. Thank you so much, Tequisha. And I'm going to turn it over to Kathy for some either final remarks or anything that Kathy has to say.
Okay, thanks, Alexis. Well, I'm the disaster coordinator attorney here at Legal Services in North Florida. So I want to talk a little bit about disasters. Right now, we're about to enter hurricane season. And just this week, NOAA said that we were going to have an above normal hurricane season with 14 to 21 named storms expected. And of those named storms, 6 to 10 are expected to be hurricanes, and 3 to 6 could be major hurricanes. So this is the time to prepare for hurricane season. There are lots of statistics and data out there that seniors are the least prepared for hurricane season. I just recently saw a study. It said only about 25% of seniors had done anything to prepare for the upcoming or for any hurricane season. So as you're talking to your clients and you're seeing them whenever in your offices, start talking about hurricane prep, because now is the time to do that. The first thing is, if you have a client who has to evacuate and they're going to need help evacuating, then they need to get on and register on the special needs registry. They can do that online, Florida Special Needs Registry. You can help them do that. Or they can request a paper application that you're going to have to put some identifying information in there and tell what problems you have if you had to evacuate, because that way emergency management will know that you're an at-risk person, and they will come with what they need to transport you to a shelter or to some other place. So go ahead and do that now. Don't wait till the middle of the storm. It's too late, because once the storm gets bad, even emergency management is not going to be able to get to you. So that's probably step 1. And then come up with an evacuation plan if you have to evacuate. Think about where are you going to go. It'd be much better if you could go to a friend's house or a relative's house, because it would be easier for you. If not, find out where the shelters are. You again do that by calling 211 or go to your local emergency management so you can figure out where you would go if there's an evacuation order and how to get there. And then think about what you need to take. You're going to need to take some clothes, maybe about 3 days worth of clothes. You know, you're not going to need to take your medicine. You're going to need to have some cash, your bank card. If the ATMs are working, that's why you would need cash. So all of that, don't forget about your pet, because if it is a pet, not all shelters take a pet. So you have to think about that. They'll take, of course, a service animal because that's not considered a pet, but all of them are not going to take your pet. So make plans for your pet. Don't forget to bring them some food. If you're going to someone's house or you're going to a hotel, take along what your pet may need at that hotel. And then also, I always tell people this is take a picture of your house before the storm, because people who are the adjusters and FEMA, they might look at your house, and if it's older, they might think that that damage was done before the storm and they don't want to give you any money. So take a picture before the storm of your house, all around it, inside and outside, your belongings. So when you apply for assistance, you'll be able to say, this is how it looked before, this is how it looks now. You can easily see that it's related to the disaster. And then one thing that Tequisha said, well, everything she said was important, but one thing that stuck with me was the air property. Think about, do you really own your own place? Or are you living in a place that you've been living for years that used to be great grandmas or grandmas or your dads or your brothers, and you're just one of 26 people that own it? So think about that, because now is the time, like Tequisha said, to get that cleared up, to probate the property, and to get it into hopefully your name, because I guarantee you will have a difficult time getting disaster assistance for a home that you do not own. FEMA just this year expanded the documents that they would use to prove home ownership. So you might be able to get a little money from FEMA if your home is damaged, but you won't, that only makes your home safe and sanitary to live in. It doesn't get it back to where it is before. And a lot of people with air property, because they don't have a mortgage, they don't have insurance. So there's not going to be any insurance for you. And so then when you apply for the big, what I call the big money from the community development block grants and other kinds of assistance, you're required to be a homeowner. So a document, a little piece of paper from someplace saying, yeah, you've been living at that address for 20 years will not do it to get that kind of money. So you need to start doing what Tequisha said, and that is probate. So the first thing before you go to the attorney, go ahead and write up your family tree so they know who all your relatives are before you get there. Because if you're going to a private attorney, you're paying for their time to find out what you already know. So go ahead and do that. And then pay attention during the storm to the news, and be alert as to what's going on, and be prepared if you have to go and to get what you need. And also, you know, put away the things that might blow in your yard, move things around. I know when I'm thinking about getting ready for hurricane season, I start eating all that food, cooking the food that's in the freezer. You know, if you've got a refrigerator or the freezer, go ahead and get rid of that, because if the electricity goes on, you're not going to be eating that, goes off, you're not going to be eating that after the storm. And then afterwards, of course, when it's safe to go outside, take a picture of all the damages. Be very wary of contractors that are coming to your door, encouraging you that they can do the work right away. Talk to your clients about not signing anything until they maybe talk to an attorney or to a trusted family member or neighbor before they sign an assignment of benefits, or they get some contractor who says, I'm going to do this, or they pay to get their roof tarped. When FEMA and other organizations are coming around and tarping roofs for free. So be very wary of that. Look for the Disaster Recovery Center and go there where you can apply for FEMA benefits. The best thing to do is prepare for the storm before the storm happens. And then you'll maybe be able to limit the damage that you have to your property and personal belongings. And so I'm the last person today to do the rapid fire panel. And we really did do that rapidly. So we will be able to let everybody go quickly. Did anyone else want to add anything that we haven't talked about today, or I'll just close it out? Okay, well, first of all, this group that you're heard today, in addition to Sarah Halsell with the Florida Department of Elder Affairs and Ellen Cheek with Bay Area Legal Services, was the design team for the conference. So major big thank you to them for all of the phone calls and meetings and exchange of emails that we had to come up with the agenda that we hope you got something out of and that you benefited professionally by being here these last 3 afternoons. Big support to Sarah and the Florida Department of Elder Affairs, because without their support, we wouldn't be having this conference. And to our other co-hosts, Florida Legal Services, the Florida Health Justice Project, Legal Services of North Florida, and Legal Services of Greater Miami, who are also co-hosting the conference today. And thank you all for attending and being a part of this conference.